Certainly, we did advise on cautions.
Was there a statutory basis for the Post Office issuing cautions?
I think we basically applied the prosecutor's code.
That doesn't address cautions.
So we're jumping back into Jarnail Singh's testimony, and he's going to be discussing, Jason B, with Jarnail Singh, the Post Office's power to issue cautions and on what basis this power was derived from. Was it a statutory basis? Was there some special powers given to them? And how did they administer said cautions? Although Jarnail Singh seems to be getting very confused because he seems to reference a prosecutor's code that doesn't even cover cautions. Let's see what he has to say and jump into the inquiry.
Were cautions an available outcome? That can come down.
Sorry?
Were cautions an available outcome?
Yes, I think yesterday we discussed it, yes.
Was there a statutory basis for the Post Office issuing cautions to suspected offenders?
I'm sorry, I don't understand. I mean, the normal... What do you mean statutory? It's something that we considered, yes. I mean, after the evidence, the next bit is whether there's an alternative way of dealing with it, and in light of the public interest.
Where did the power come from for the Post Office to issue a caution?
I mean, certainly we advised as to how it's given, who gives the caution, whether the police does it for the Post Office or the police got any statutory powers. I don't know.
Well, the police do have powers to issue a caution, but this is sounding very much like not only are we encroaching as a post office here on the police force by almost forming our own kind of quasi law enforcement agency, but now we're cautioning people as well. I mean, presumably that can't go on a criminal record, can it? I mean, surely not. Surely they weren't having this much power, but I'm sure a lawyer will be able to let me know in the comments what the case is with this. But the post office issuing cautions, what?
I can't. I mean, maybe at that time I did know, but what the system was or what the procedure was or what the basis was, certainly we did advise on cautions. I think in every single case we considered it's always, the evidential test and then the public interest. And public interest, one of them was the fact there was alternative ways of dealing with it rather than, prosecution.
And so was this a consistent practice over the entirety of the period that we're talking about, from August 1995 until, say, April 2012?
You mean the consideration for caution?
Yeah.
Certainly on my cases, I had a checklist of going through it. And first the evidential test and the public interest, and there was the alternative way of disposing it, without resorting to prosecution. But then majority of the time is the breach of trust and the fact the amount of loss involved, or amount of loss.
Was there a Post Office policy which regulated when and in what circumstances cautions should be offered to suspected offenders?
I think we basically applied the prosecutor's code. If it's in there, then certainly, but certainly
the code for Crown Prosecutors.
We applied a code if it was in there. Come on now. I mean, this was his Bible, he said, almost. This was what he constantly referred to. Didn't know whether the Post Office had any policies, but he always referred to the code for Crown Prosecutors. Now, I'm not sure whether it's in there or not, but the fact that he's not sure is the more worrying thing.
Prosecutors.
Yeah, sorry.
That doesn't address cautions.
But then, but certainly, that's maybe in our training or the way we looked at the case, we certainly considered it. I mean,
what were the relevant considerations in deciding whether to offer a suspected offender a caution?
Well, in any circumstances, in the sense that the amount involved, the recovery.
The amount involved?
Yeah.
So what was a permissible level of amount involved for a caution and what was an impermissible amount?
I wouldn't, but it depends on the circumstances, the whole circumstance of the case. But I think around about 5,000, I think is the figure of 5,000 comes to mind.
So if it was below that amount, then a caution was permissible, is that right?
I think there was no strict figure, but that was the figure. I think the figure they mentioned that we ought to pay more attention to.
I thought, though, with the less than 5,000 ones, they didn't pursue them at all. Now he's saying they're offering them a caution. I thought they didn't get involved with cases below 5,000 at any point, and that eventually that limit was raised to 10 and 20,000 subsequently.
The next thing you said was the recovery. What does the
Well,
recovery?
if it was a short period of offending, always just one-off offence, or the circumstances around it, persons, the health issues, or the personal persons.
No, you're talking about different things now. So I was asking about the thing you just mentioned, which was you said and the recovery.
Well, I think
what did that mean?
If the money's repaid, that's what it means.
Was that a condition of issuing a
No,
caution?
there's no condition. It's a consideration. That's the sort of.
What was a consideration?
Well, that is kind of putting pressure on someone in the same way where you're saying we're going to take you to court for theft, but if you plead guilty to false accounting, you might stay out of prison, is an incentive even for an innocent person who's scared of going to prison to plead guilty to that, saying, well, if actually you pay us back the money, even if you say you didn't steal it, and we'll only give you a caution. Again, that's incentivising people to actually maybe repay money they don't have and haven't taken on the basis that they'll avoid a criminal prosecution.
The amount lost and the amount recovered. I think that's one of the bases of.
So had the amount had to have been recovered in order to issue a caution?
To be honest, this is going back a few years, or lots of years, number of years. I've been doing other things. Now I don't know. You probably put me on the spot, so I can't give you a definitive answer on that. But certainly it was considered. I think any case I dealt with is I always played my mind to it.
You went on to mention health. Is that the health of the suspected offender?
I think and the family. I think any surrounding circumstances, anything and everything.
Were there any other considerations brought into account? You said the amount of the loss, whether it had been recovered, i.e. whether the postmaster had paid it back, and the health of the suspect and their family. In addition to those three things, was anything else brought into account?
I don't know. I mean, I can't give you a definitive answer because it's such a long time ago since I left the post office and left the prosecution. Prosecution generally, I've been doing other things, as you know. I don't know the answer to that.
What about an admission?
Well, obviously
of guilt by the offender, which in the outside world, outside the post office, is
full and frank.
A condition precedent to the issuing of a
full and frank
caution.
admissions. Yes. That is one of it, isn't it? Yeah.
Is that a fourth thing then?
Well, it's important. Yes, it's got to be, hasn't it?
And can you remember any guidance or written document that told you and the other senior lawyers how to approach this issue?
I think it's certainly. I don't know about internal document or internal training now, but certainly the outside training. We had the central law training. I certainly regularly attended. There was the training.
Was that training about cautions?
Well, some of the trainings were about cautions. Yes.
So you received training from central law, did you say?
It's central law training, where you get your CPD points each and every year.
That was training about cautions?
Well, one of the topics would have been, I would have thought, I can't tell you which one. And then certainly Chambers, I think, did quite a lot of training, whether it was on caution, but certainly on the subjects we were sort of interested in. I don't know whether somebody mentioned it and they applied, they trained us on that, or what sort of considerations that go in it. But such a long time ago. But there was a lot of training, but I don't know whether it was actually a post office manual we applied to. Whether it was written down internally, I can't really say one way or the other whether it was or not.
Was there a process that had to be gone through for the authorising of caution?
Well, that's something we advised on or recommended, but as to how it's applied, I couldn't tell you. It's such a long time ago as to how they did it, but I think it's certainly the security or the investigation team carried that out. They're the ones who carried it forward as to how they administered it, whether they had the authority.
Never mind the administering of it at the moment. I'm thinking about who decided that a caution was appropriate.
Well, it was obviously the legal team. I think
You were the decision makers.
we recommended it. We didn't make the decision. We recommended
Okay, to whom did you recommend it?
to the security team. We passed it to the prosecution support office, and who in turn, I think, passed it on to the decision maker or the designated decision maker, I think.
And would that designated decision maker have changed over time? Sometimes it being somebody in HR, I believe, and then it changed to being the head of security.
It was yes, I think it probably did. But what I'm saying is that we went to the prosecution support office. They in turn passed it on to the appropriate person, whoever was the designated authority at that particular moment in time.
And so, as matters stand now, you can't help us with the power that the Post Office used to issue cautions to offenders, nor whether there existed guidelines regulating the circumstances in which such a caution could be issued.
I'm trying to think.
Surely they can't have had some special power to caution people like the police. Surely not. No. And if they did and had no guidelines on using it, that'd be willy-nilly, wouldn't it? Could you imagine the police, who have the power to issue cautions, having zero guidelines on it? Oh yeah, we know you've committed a major crime, but it's kind of in our interest just to caution you as long as you give us the 20 grand back that we think you've stolen. I mean, it'd beg a belief, wouldn't it?
As the practicality of it. I mean, it's just too long a period between the when I was advising on it and since I left. I can't. No, I don't think I can help you with any more than what I have.
Thank you.